Welcome to Court Helicopter Explainer, where we are dealing with the dancing king, Fala. Music is called Fala. What does Fala mean? A stupid mongoloid, a person not intelligent, a person who is gullible, a person who cannot exercise his or her intellectual faculties. Somebody who can't see an obvious thing. Everybody sees he's being duped or she's being duped, but he believes he loves. What is love? Love is when two people agree to be fools. Because love has no eyes. Love is blind. Kipenda roho ni chongo. When you love, you don't see. Mzee Kibore loved, yet what he was loving, there's nothing to love. He became a fool. Ni Fala. How many of us have fallen into this trap? You love intensely. You take all the money you have, you buy, you invest in this woman. She means everything to you. She's your life. You can't breathe without her. You can't miss to see her daily. You can't miss to call her daily. She has turned you to a Fala. You love intensely. You put all your emotions, all your finances there. You go to steal to give her. You deny your family, you give her. After she has gotten what she wants, she dumps you. That's why it's called a Fala. Are you aware there are people who are married and they have run away literally from their wives and went to live with the people's wives? Are you aware there are people who carry their TV, the TV that their children and their wives are watching, they carry that to a woman? Are you aware there are people who do that? Can you carry your TV and take it to another woman's house and you leave your children without a TV? Do you know there are people who buy land? You take money, you buy land. No wonder they are called Fala. Has this thing ever reached to the Kenyan court, the Kenyan Supreme Court? Yes. What did the Supreme Court of Kenya say? This is a judgment from the Supreme Court of Kenya in petition number 9 of 2021, where we have Mary Nyambura Kangara allows Mary Nyambura Paul as the petitioner versus Paul Ogari Mayaka, the respondent. What are the facts of this matter? I'll read, you'll get interested. He says, the respondent that we have agreed, the respondent is Paul Ogari Mayaka. The respondent instituted Nairobi High Court Civil Suit number 6 of 2012, POM versus MNK, by way of an originating summons dated 5th November 2013, against the appellant whom he claimed to be his wife. The respondent invoked the provisions of Section 17 of the Married Women's Property Act of 1882 on the claim for division of matrimonial property. The story starts on paragraph 3. The respondent's contention was that is the man, he and the woman began to cohabit as husband and wife sometime in 1986. It was his case that from joint savings, they purchased the suit property. They saved together and they bought the property. He asserted that he belonged to the Kisii tribe. This man was coming from my tribe, the Kisii tribe. And the seller, who belonged to the Kikuyu tribe, was not comfortable selling the parcel of land to a non-Kikuyu. So they wanted to buy land from a Kikuyu. Very interesting. But the Kikuyu said, I cannot sell land to a non-Kikuyu. This man, that is not acceptable. That is wrong. Discriminating based on tribe. Remember, we talked on Article 27. You can't be denied to buy land just because you are a Kisii. So this was wrong, but this was not the question before the Supreme Court. If Ogari went to court for discrimination, that man could have been arrested. The Kikuyu seller could have been arrested. But that is not here. The parties resolved to have the property registered in the woman's name, although they had both contributed to its acquisition. The woman is a Kikuyu. The man is Kisii. The seller of the land is Kikuyu. Don't tell me whether it was a plot between the seller and the woman. I don't know. But the seller refused that he cannot do a sale agreement to a Kisii. So they agreed. Then I have a wife who is a Kikuyu. So the property was, the sale agreement and the title deed was registered in the name of Mary Nyambura Kangara alone. But they saved together. They wanted to buy the land together. But because of this complication by the seller, the land was registered in the name of the woman alone. Have you bought land and your man has told you as a woman, or your woman has told you, here, you must register this land in my name? Because the lady is lawyer. She tells you, we are buying land in Kakamega. If land clashes arise, then they find that your name is Danson Omari here, and you are a Kisii, nyumba itachomwa. Register the land in my name. Mafala ni wengi. People are laughing. Have you been made a fool by being told that if you buy and register this land in my name, you are safe? This is what happened in the Supreme Court. According to the man, the parties took possession of the parcel of land between 1992 and 1993, which they developed and constructed rooms thereon, one of which they used as their matrimonial home, and let the other rooms out. It was his case that he did the legwork relating to the connection of electricity, sewerage, and water to the premises. So after buying the land, they constructed. The man, this Ogari man, this Kisii man, connected sewage, electricity, and all these things. He claimed, in addition, he operated a bar from the premises. He put a nyama choma banda there. My brother from Kisii, he's trying, but he's going to be made a big fella shortly. He's no difference from Kibore. Let us see. He claimed that the appellant, now the woman, evicted him from their matrimonial home in 2011. My brother, in 2011, he was chased. And at this time, the amount of rent collected from the premises was per month 258,100. Besha zinaingia. 258,000 every month. The man was evicted. He was made a falla. He was chased. Remember, this man says they started cohabiting 1986. He took money and bought land in 2011. This is more than 30 years or 20-something years. He's chased. He's evicted. This is his story. Let us hear the story of the woman. Mary atasema nini? Msichana wa Kibore ndio huyu. Sikiza. Anasema, the appellant rejected all the respondents' claims. She say she denied his involvement in the purchase of their suit property. His contention or registration of the property, urging that she allowed him to manage the suit property because they were friends. According to Mary, the property was bought by her. He only allowed him to manage the property because the property belonged to her. According to her, she was already married under customary law to a one man called KM. So, this is the time Mary is now saying, me, I was already married. Remember in 1986, the man was never told by Mary that Mary was married. Mary kept that as a top secret. In 2011, when Mary is chasing Ogari, that's when he says, me, I'm still married. Do you remember the case of Linturi and Marianne? I was an advocate in that matter. Marianne at last lost because Linturi never divorced the wife. They were separate, they stayed for separate, but when the dispute arose, Marianne invested heavily. Marianne got children with Linturi after divorcing the first wife. Marianne, the decision of the Court of Appeal, we are going to deal with it. Linturi brought up the order, the marriage certificate. Now that man is deceased, and though they were separated, she never divorced him. Therefore, she did not have the capacity to contract another marriage while her first marriage was still subsisting. She also claimed that after KM died in 2011, the respondent intensified the harassment to coerce her into marriage. She subsequently filed CMCC case number 4364 of 2011 to restrain the respondent from trespassing into her properties. The learned judge, Justice Musyoka, found out that she had no capacity to marry. So the question is, what do you do with the property? What do you do with the property? The judges looked at whether this man contributed. The judges found out. He says, what the judges said, paragraph 90. Applying the above guidelines, we reiterate that common intention of the parties at the time of purchase of the suit property gave rise to a constructive trust between the appellant and the respondent. From the evidence on record, that the appellant and respondent had been cohabiting since 1986, and that in 1991, the suit property was bought by the two parties and registered in the name of the woman. The man was present during the drafting and signing of the sale agreement, and was in fact a witness. This man was a witness, Ogari. The parties lived in one of the rooms from 1993 and plowed the proceeds of rent to construct more rental units. It was proved that the meters were in his name. Meters are electricity. The man was a bright kisi. Meters are stima aliweka kwa jina yake, and operated a bar on the same premises. In these circumstances, we conclude that there was a common intention for the appellant and respondent to have beneficial interests in the sued property. However, in 2011, when the parties herein separated, the woman evicted the man from the matrimonial home and from the business premises, contrary to the common intention they had at the time of purchasing the property, thereby unjustly enriching herself with a property meant to be of benefit to her and him. Paragraph 92. It is in evidence that the man paid for the water and electricity connection charges and bills from when the property was constructed in 2011, when he was evicted from the property, and that jointly the parties have made several improvements on the sued property. It is therefore our finding that the common intention can be inferred from the appellant and the respondent's conduct during the existence of their relationship. Paragraph 93, having established that there was a common intention and that both the appellant and the respondent should have beneficial interest in the property, it follows that we need to proceed and quantify the beneficial interest to the parties. In assessing the beneficial interests due to the parties, we can not only be primarily focused on the direct financial contribution to the acquisition of the property, but also interrogate other forms of contribution, such as actions of the parties in maintaining and improving such properties. What did the Supreme Court order? The record shows that the appellant, that's the woman, and the man jointly contributed to the acquisition and the construction of the sold property, and the two jointly invested in the property for more than 20 years. Therefore, we are of the view that the man did prove his case on a balance of probabilities that the sold property was acquired and developed through joint efforts and or contribution of the parties. We therefore make a finding that the share of the parties is apportioned as 70% for the woman and 30% for the man based on their respective contributions. This is the judgment of the Supreme Court. Kibore, our Kibore in this matter, Kologari, got 30%. The woman got 70%. So what are we trying to teach you? Instead of killing, instead of femicide, instead of going to harass this woman, you are not a falla. Walk to court. This is a matter that started from the High Court. It went to the Court of Appeal, and our dancing Kibore here called Paul Ogari Mayaka got 30% of the property. So it's not lost for Mzee Kibore. The law is on his side. What we are trying to advocate, the many men, the many Mubabas who have been hit here, the many Wabamas who have been hit by love, by investing, don't take the law into your hands. You can walk up to the Supreme Court and you can recover whatever that is owed for you. Wakili, dance Romari, always in the dancing mode, but not as a falla, but as telling you, you are not a falla. Don't hold your head and say, woy, 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 mi nitaua mtu. Mimi nitaua mtu. Don't. Go to court. You'll get your day in court. Keep watching as the episodes are rolling. We promised 15 legal episodes out of the Mzee Kibore dancing video. Asante.